Hello and good morning or good afternoon to where you are joining us from today, and welcome to My HR Council's February 3rd Tuesday webinar. Today we will cover the FLSA and state and wage and hour laws. My name is Dan Johnson. I'm the Director of Marketing and Customer Experience here at My HR Council. Before we get started, I just wanted to remind you that today's webinar is being recorded, so if you need to hop off, we will have that webinar recorded for you. We will send it in an email follow-up later this week, and that email follow-up is also going to include the slide deck, the HRCA credit, and more information on this topic. In addition, we also post our webinars on our YouTube channel. And to get there, all you do is search My HR Council and you'll find our channel full of our whole library of previous webinars. And then you'll also be able to see today's webinar as well. In that follow-up email, we're also going to include a brief survey for attendees, and we highly encourage you to complete that. The results of the survey are very important for us, and it's going to provide us with potential topics for upcoming webinars, as well as important feedback on how we can improve our webinars going forward. And now I'll pass it off to our host, Britt Waterman, who is a senior attorney here at My HR Council. Thanks, Britt.
Thanks, Dan. Welcome to everyone. Thank you for taking the time out of your day to come and join me for the third Tuesday webinar. Today, we're talking about Wage and Hour 101, and it includes the Fair Labor Standards Act, Wage and Hour FAQs, and a lot of these topics come directly from client questions that I get every day. So wage and hour may seem like a very basic topic, but it's crucial that you follow these laws to the letter. I mean, one slip, one aggrieved employee, and the DOL can come in and tear apart your payroll records for every single one of your employees for the last 3 years. And that 3 years is a record retention requirement that is in the Fair Labor Standards Act, so you should know that. There are no secrets. The FLSA is a published statute. It's available for anyone to go online and read, but it's shaped by guidance, case law, opinion letters. There's so much more to the FLSA and 51 similar state laws, including DC, that have having an experienced employment law attorney to research and interpret this information is so necessary to keep your company in compliance. So My HR Council really has the solution to the compliance questions in this area. So in the last slide here, we'll give you some more information on how to sign up if you're not already a client, or if you have questions on how to submit a question if you are a client. We'll have more information. So the Fair Labor Standards Act passed back in 1938. Again, my favorite employment law trivia question is the first female Secretary of Labor. Everyone who's seen the movie Dirty Dancing knows that when Baby tells Johnny her real first name, she says her real first name is Frances, and her father named her after the first female Secretary of the Department of Labor. That is Frances Perkins. She was back in our webinar on unemployment because she was kind of the mother of unemployment. She's back here pushing the Fair Labor Standards Act of 1938. The Fair Labor Standards Act it's been amended 19 times, and so many additions, so many proposed additions. It's constantly evolving. It's one of those laws that's just never really written in stone. It's a living, breathing thing. It includes the Portal Act. We'll get into that in a little bit here. The Equal Pay Act. With the Equal Pay Act, if you're discriminating on the basis, and the Age Discrimination and Employment Act, now if you're discriminating pay-wise on the basis of sex or age, you are violating the FLSA. You also might be violating the Civil Rights Act or the ADA, in which case you would be dealing with both the Department of Labor for the FLSA and the EEOC for Title VII or the ADA. Now, EEOC settlements can get into the six figures, as we know. FLSA violations can get you criminally prosecuted. You can get fined anywhere from $1,000 to $10,000 per violation. And again, as I said, one aggrieved employee gets your whole payroll ripped open, and they're looking at every employee, and that's per violation. It depends on what you violate. So also, just like violating Title VII or the ADA, employees can file a private lawsuit against the employer for an FLSA violation. One particular employer paid out $5.8 million for failing to maintain accurate time records. And we will talk about record keeping briefly, but that's just for the violation was just not keeping the time records, and it went into the multi-million-dollar settlement. If you violate the Equal Pay Act or the Age Discrimination in Employment Act, and your employee runs to a plaintiff's attorney, that attorney is going to smell blood in the water when it comes to the FLSA and try to tack on claims for overtime, minimum wage, record keeping. They are going to want to go through everything. Do not let them find one mistake, because if their mistakes are like cockroaches, if there's one, there's 100 of them. So you want to be careful that you are always compliant across the board. Do not leave a hole anywhere. So what's in the FLSA? So these are the items covered by the FLSA. Some people don't know child labor is in there. That's something that's covered. I'm not going to talk about child labor laws today, but of course, if you have any questions about child labor, please submit a ticket, ask us a question. We're always happy. We're experts on child labor laws, both federal and state, and can answer that for you. All states have some kind of a mini FLSA or a law like this, even if it's just to set their minimum wage. Now, a state can give an employee more protection, or it can strengthen the FLSA. They can't take away employees' rights and weaken the FLSA. So if you're ever faced with a situation where state and federal law conflict, choose the more employee-friendly option. If the FLSA says overtime is 1.5 times the regular rate of pay for hours worked over 40 in the work week, your state can't say, well, it's 1.25 times the regular rate of pay. They can't make it less. They can only make it more. Other laws may wind in and intersect along the way. FLSA is not the only law with record-keeping requirements, for example. It's important to check with counsel to make sure you're following record-keeping requirements on all of the laws that require them, not just the FLSA. Within these categories, there are subcategories. Minimum wage is not just a dollar amount. It includes other subcategories. Overtime is not just counting hours up to 40, but there's calculating the regular rate of pay. There are the exemptions, both of which we will get into. So what's not in the FLSA? The FLSA does not require vacation, holiday, severance, or sick pay. The FLSA does not require meal or rest periods, breaks. It does not require holidays off. It does not require vacations. That's a question I get quite frequently is, do we have to pay this employee if we require them to work on Labor Day, or do we have to give the employee the day off on Christmas? And the FLSA does not require that. It does not require holiday pay. It does not require premium pay. If you require an employee who usually works Monday through Friday to work on Sunday, or if you require an employee to work on Thanksgiving, you do not have to. The FLSA, the federal law, does not require you to pay them a higher rate for working on those days. Of course, if those days cause them to go over 40 hours, then you have to pay the overtime rate for any hours over 40. That's if they go over 40, but you don't need to pay a higher rate for weekend or holiday work, except, and I'm going to, this is going to be my refrain for just about every slide in the deck. State law, Massachusetts and Rhode Island have laws regarding premium pay on weekends and holidays off. So if you're operating in Massachusetts and Rhode Island and you're wondering about premium pay or time off for weekends and holidays, please send in a ticket, let us know, because although the FLSA does not require or govern it, your state law does. It doesn't, the FLSA does not cover pay raises, fringe benefits, anything having to do with what you have to do when an employee is terminated, or the number of hours in a day or days in a week that an employee may be scheduled to work if they're at least 16, going back to that child labor law. So this is where your state law is going to come in. So many cities and states have had pay sick leave for years, and this is a frequent proposal each legislative session at the state level in many states. Maine and Nevada have had paid leave that can be used for any reason for a while now, so that's state kind of offering vacation pay. Offering group health benefits may be required by the Affordable Care Act, but it is not a part of the FLSA. Giving a discharge notice, 11 states require some kind of termination notice. Usually it is a form from the state's Department of Labor that has to be specifically filled out. This is often for unemployment purposes that the state's requiring that form. But that's only 11 states that require that discharge notice. It's not in the FLSA, it's not federal law. A reason for termination, Montana is the only state that does not have at-will employment. Someone has to be fired for cause. Some states like Minnesota require employers to provide the reason for discharge upon request. So that's something to keep up with counsel. Payment of final wages. If you do not know, ask counsel before the last day of employment. California famously requires final wages at the time and place of termination, and that includes commissions and accrued but unused PTO. Texas is maybe a less employee-friendly state than California, but they still only give you 6 calendar days to come up with all of the employees' final wages. Louisiana may be a little more employer-friendly. It's 15 days or the next payday, whichever is sooner. Some states have different laws for if somebody is terminated or if they quit. You need to be keeping up with that if you operate in different states. Although the FLSA does not say anything about the number of hours in a day or days in a week, your employee may be scheduled to work that may be affected by state law. Illinois has their 1 day's rest in 7 law, for example. There are predictive scheduling laws in a number of cities and states that may affect that. The FLSA does not provide wage payment or collection procedures for an employee's usual or promised wages or commissions in excess of what's required by the FLSA. However, some states do have laws under which these claims can be filed. So who is not covered by the FLSA? Independent contractors, volunteers, and unpaid interns are not covered by the FLSA. You do not have to pay them minimum wage. You do not have to pay them overtime. None of the rules in the FLSA apply to independent contractors, volunteers, and unpaid interns. This sounds great, right? But do not call all of your workers independent contractors just to get around the FLSA. The IRS and the Department of Labor will tag team you if you do this. Follow the IRS test for determining whether someone is an independent contractor, or your state's test if your state's test is more restrictive. But if someone is an independent contractor and you want to pay them $20 for a 5-hour job, you can. as long as they are truly an independent contractor and you're using that test to determine. But you better make sure they're not an employee, and you should consult with counsel if there's any doubt in your mind. Volunteers, if the organization is not a covered entity, the FLSA does not apply. Some nonprofits, religious charitable organizations are not covered entities. They are not covered by the FLSA as a whole, as a business. And so their employees and volunteers would not be covered. For nonprofits that engage in sales, like have a gift shop or give fee for services, or have other business related purposes, or if they compete with other nonprofits, or if there are other factors, check with counsel for an analysis on this, as if you've got a nonprofit or a religious organization, as to whether you're covered. If you are covered, an employee is or an individual is only a volunteer if they volunteer, number one, freely for public service, religious, or humanitarian objectives, and two, without contemplation or receipt of compensation. That is the law. The DOL has established whether a worker can be considered a volunteer, and they can't be, it has to be public service, religious, or humanitarian objectives, and they can't be expecting any sort of payment. Typically, volunteers serve on a part-time basis. They do not displace regular employed workers or perform work that would otherwise be performed by regular employees. If you have always had an admin or a receptionist that is a paid employee, for example, and times are tight, you cannot have a member of your nonprofit volunteer to take over the position. That's displacing a paid employee. If you are a covered nonprofit, like a church, your employees cannot volunteer to do their own jobs or other people's jobs for free to help out. They can only volunteer to do things that other members of the community or nonprofit would have done for free, such as handout programs at a church would be an example. Unpaid interns. Does the internship need to be paid? The DOL uses the primary beneficiary test. If the company or the organization is the primary beneficiary of the intern's work, then the internship needs to be paid. If the intern is getting the primary benefit of the work, then it can be unpaid. The DOL has 7 criteria. There has to be a very clear understanding that there will be no compensation. The internship has to provide training that is similar to an educational environment. It has to be tied to the intern's formal education program by integrated coursework or the receipt of academic credit. It has to correspond to the academic calendar. It has to be limited in duration and to the period that it's providing the intern with beneficial learning. The intern's work has to complement rather than displace the work of paid employees. Again, if you've got an intern coming in and they're doing a job that was normally done by a paid employee, that's not an unpaid intern. They can't displace a paid employee. And the extent to which the intern and the employer understand that there is no entitlement to a paid job at the conclusion of the internship. So really, unpaid interns are going to be interns that are doing this for school credit and getting academic credit and getting hands-on learning that complements their education. They're getting the benefit out of it. Those are unpaid interns. Anyone who's doing anything for you or giving you any kind of benefit is going to be paid under that 7-factor test by the DOL. Minimum wage. The federal minimum wage is $7.25 per hour and has been since July 24th, 2009. So employers, I'm on your side. I'm your counsel. A Big Mac cost $3.57 in 2009. Now it's $4.67 in Virginia, for example, but Virginia is still at the federal minimum wage. They haven't increased. Is that fair? Does that reflect the rate at which prices are increasing for consumers? I mean, look at the numbers and kind of think about where we're going with the federal minimum wage. But that is where it stands, and there are definitely proposals to increase that in Congress quite regularly, and none of them have passed. California, highest statewide minimum wage at $15 per hour. Seattle, highest citywide at $17.27 per hour. So any governmental body can make their own minimum wage. There are sub-minimum wage allowed in certain circumstances. Depends on your state's mini FLSA law. Some states do not allow sub-minimum wage for any reason. Overtime. So here's where we get deep into state law again. California with their 1.5 times the regular rate for over 8 in a day for the first 8 hours on the 7th consecutive day, double time after 12 hours. Some states like California add to this 1.5 times the regular rate of pay for all hours worked over 40 in a work week. That is in the FLSA. Again, your state can do whatever they want as long as it's more employee friendly, not less. They can give your employees more overtime. They can make them more eligible overtime. They cannot make them less eligible. No averaging of work weeks. Each work week, 168 hours stands alone. There is no, well, our period is 2 weeks and Joe worked 35 hours this week and 45 hours the next week. We average those two together and it comes out to 40 each week. Don't do that. A word on comp time. Compensatory time off is giving employees PTO to be used in the future instead of paying them overtime. This is permitted for government employers only. The FLSA does not allow this for private sector employers. They must receive overtime pay. So you may have heard of comp time. You may be unsure as to whether or not that's something that's legal for you. Your employees may ask you, hey, instead of paying me for the hours I work over 40, can I just have more PTO instead? It doesn't matter if your employees ask for it or if that's what they want. Comp time is not permitted for private sector employers. The FLSA requires that they receive that overtime pay. So overtime must be paid 1.5 times the regular rate of pay. Well, how do we determine the regular rate of pay if you don't have an employee who is working a straight hourly basis all of the time, no benefits, no perks, nothing changes? The FLSA has criteria that you can walk through to determine whether a payment or a benefit should be included or excluded when you're adding all of the compensation up and dividing by the hours worked to find the regular rate of pay. Premium pay can be can be excluded. Premium pay would be paying at least 1.5 times the hourly rate for working additional hours that do not qualify for overtime. So if you've got an employee who maybe works on a Saturday and they don't usually work on a Saturday, so you say, thank you for coming in on Saturday, we'll pay you 1.5 times your wage, but it's not giving them overtime. That would be premium pay, and that could be excluded from the regular rate of pay, or if you pay them more for more than 8 hours in a day. Again, watch out, California, or working on weekends and holidays, premium pay for that. Again, watch out, Massachusetts and Rhode Island. But generally, paying at 1.5 times the hourly rate or more can be considered premium pay and can be excluded. The difference between a discretionary, which is excluded, and a non-discretionary, which is included in calculating the regular rate of pay. Discretionary bonus is at the sole discretion of the employer and is not expected or part of any prior contract, agreement, or bonus. A discretionary bonus would be considered an employee of the month bonus, a referral bonus, but only if the employee is not normally a recruiter, someone who is normally a recruiter and got a referral bonus. That would most likely be a non-discretionary bonus, but an employer refer a friend and get $50, that's going to be a discretionary bonus, and you can exclude that. A bonus for overcoming a challenging or stressful situation. I think we saw a lot of those over the past couple years with the pandemic, some bonuses for going above and beyond, working extra hard, kind of facing a challenging situation. So all of that would be a discretionary bonus, and you would not include that when you are adding up compensation to calculate the regular rate of pay. A non-discretionary bonus, you're always going to have to throw that in there to calculate the regular rate of pay for overtime. A non-discretionary bonus would be attendance bonuses, performance bonuses, bonuses for the quality and accuracy of the work, bonuses to induce employees to work more efficiently, sales bonuses, bonuses that are in the offer letter or the employment contract, anything that the employee has to do to get the bonus, and it's known that when you do X, you get Y, that is a non-discretionary bonus. So things like vacation, PTO, a PTO buyback would be excluded from the regular rate of pay. Reimbursement for business expenses is excluded from the regular rate of pay. That's not considering reimbursement for business expenses is not considered compensation for hours worked or services rendered. Things like employee discounts, tuition assistance, gym memberships, these kind of perks don't have to be considered in calculating the rate of pay for overtime purposes. Exempt versus non-exempt. This is something I have to clarify quite frequently because the terminology is a little confusing and has been always. So some employers call their employees hourly or salaried, when what they really mean is non-exempt and exempt. So you can have a non-exempt employee and you can pay that employee a salary, but a non-exempt employee is entitled to minimum wage and overtime. So a non-exempt employee, you can pay them a salary, a weekly salary, but at the end of the week, that salary better be enough to cover minimum wage for all hours worked and overtime for all hours worked over 40. If it doesn't, you have to make up the difference. That is why non-exempt employees are usually paid hourly and not generally paid by salary. But just saying salaried employee does not mean the same as a non-exempt employee. Non-exempt means they are entitled to minimum wage and overtime. Exempt employees get paid to get the job done. They get paid for the quality and the quantity of the work that is completed, not the amount of time that it takes them to do it. Exempt employees must be paid by salary. There is an exception with the computer professional exemption that can be paid hourly. We'll get to that in just a moment. But in order for an employee to be exempt from minimum wage and overtime, they do generally have to be paid on a salary basis. You cannot pay someone other than that one exemption hourly, but not pay them minimum wage and overtime. You must track your non-exempt employees' time accurately to make sure they're getting at least minimum wage and overtime. So a non-exempt employee, you have to track their time. You can make your exempt employees punch in and punch out if you want to know where they are. You just can't tie their pay to the number of hours that they work. White collar exemptions. So these are the executive, administrative, professional, outside sales, and computer professionals exemption that you have to meet the salary test and the duties test, that minimum salary, in order for an employee's position to be exempt from overtime. It is the position that is exempt for overtime, not the employee who is exempt from overtime, because the primary duties of the position must meet the duties test. You cannot have one employee in a position who is exempt and another employee in the exact same position who is non-exempt. It is the position, not the particular employee. You can't be rewarding one employee by entitling them to overtime and minimum wage and not rewarding the other employee. It's the position, not the employee. If you have someone in an exempt position and you start making them track their hours and you start tying their pay to the hours worked, or if you start doing something like disciplining an exempt employee for working fewer than 40 hours a week, you are treating them like a non-exempt employee. You cannot switch back and forth. If the DOL sees you disciplining an employee for working fewer than 40 hours a week, or tracking salary to hours worked, treating the position like a non-exempt position, they may require you to classify that position as non-exempt going forward. And for possibly the end of time, the person who works in that position will be eligible for minimum wage and overtime. Not all states recognize all of the exemptions. Some states do not exempt outside sales workers or computer professionals. In some states, a person in one of those positions would be non-exempt and entitled to minimum wage and overtime unless they fell under another exemption. But again, that's a state making more people eligible for minimum wage and overtime, giving more benefits to employees, not less. Some states, Arizona, do not exempt employees from minimum wage. So even if you've got someone who meets, say, the administrative exemption under the FLSA, in Arizona, they're not exempt from minimum wage, even though they're exempt from overtime. You still have to pay them minimum wage for hours worked, even though the FLSA says you don't. A state can make more people eligible, not less. Some states have a higher minimum salary. You have to check with council on that. California's minimum salary is $62,400 per year. You can compare that to the federal of $35,568 per year. So the white collar exemptions, how do you determine whether a position is exempt? This is a question I get all the time. It depends on the duties of the position. So it must meet the salary test, meaning hitting that minimum salary we just talked about, and the duties test. So you look at the primary duties of the position and you determine whether they fit the criteria laid out by the Department of Labor. So this is just a very, very brief snippet of the Department of Labor's criteria for determining whether the primary duties qualify for the exemption. The executive exemption, they have to be running a recognized division of the company, hiring and firing, or at least having a strong influence on hiring and firing. The administrative exemption, the discretion and independent judgment must be on matters of significance. Just because someone uses independent judgment about how much printer paper to order does not make them exempt. Making decisions within an established framework is usually not going to count. They must be able to go out on their own to operationally or financially bind the company. Professional exemption, academics, doctors, lawyers, teachers, accountants, generally things that you have to get a specific education to be able to do. Computer professional, this is not just going to be any help desk or tech support. This is someone who is a computer programmer, computer systems analyst. They must be implementing hardware and software. Depending on what your IT person does, they may be exempt under this exemption. It's really going to depend on how skilled they are. Outside sales, they must be obtaining orders or contracts for goods or services. It does not count if they work in your office. They must be working at the client site. They must be selling things at the client's site, calling on clients. Putting executive or managing in the job title of the position is not enough to qualify the exemption. The employee's primary duties still have to meet the DOL test. Exempt employee pay deductions. This is another very popular question. Generally, if an exempt employee works part of a work week, they get paid for the full work week. If they perform any work in a workday, if they check an email for 3 minutes, they must be paid for the entire day. One exception is intermittent FMLA. That is the only exception, or safety infractions. You can make a partial day deductions, but that's so rare. Don't even think about safety infraction, partial day deductions, because I don't want you to mess it up and have that come back and be a problem for you. So no partial day deductions. If they answer an email for 3 minutes, you got to pay them for the whole day. One or more full days, you can deduct one or more full days here. For sickness or disability, you can deduct if you have a bona fide sick leave policy in place. So if you have paid sick leave or short-term disability or some type of compensation in place if an employee is out sick, you can make a full day deduction. Even if the employee isn't eligible for the plan or has exhausted their leave, you can make a deduction. If you don't have paid sick leave or short-term disability, no full day deduction for illness or disability. If there's any week performed in the week, you must pay the full week if the reason for the absence is illness or disability. You can't deduct if the employee is ready, willing, and able to work. If you close the office because of inclement weather and they were all set to come in, you have to pay them. You can, of course, make them work from home, but if they can't work from home, you have to pay them. Deducting from the PTO bank, as long as they get their full amount of pay in the week, it doesn't matter whether the pay is coming from their salary or PTO. If they are away from work, go ahead and deduct in the smallest increment that you require employees to take their PTO in. If you let people take PTO in 1 hour increments and an exempt employee takes 2 hours off to go to the dentist, go ahead and deduct 2 hours of PTO. That is not illegal. But you should have a policy notifying your exempt employees that you're going to do this before you do it. If you do it for one employee, you should do it for all employees. It should not be a reward or a punishment type situation. Sometimes the point of being exempt is that you can work 6 hours instead of 8 one day and make up the work later, and deducting PTO for every time someone is gone for an hour or two is bad for morale and just kind of over managing, but it is legal to do this. So is it legal? Yes, you can deduct from the PTO bank. If they are out of PTO, again, no partial deductions. You have to pay them the full day, even if they only work 5 minutes. Wage deductions. So if they're primarily for the benefit of the employer, you cannot subtract so much that when you divide the employee's total pay by the number of hours worked, you come out to less than minimum wage. The employee still must be paid an amount that is at least minimum wage for hours worked. If the employee, but for example, if the employee did not work that many hours and deducting their insurance premium would take them below minimum wage, the FLSA does not prohibit that because that is for the benefit of the employee, but as always, check state law. In most states, you can terminate an employee if they come up short, or if they're a server and they have a dine and dash and you want to hold them responsible, you can terminate them. Not in all states. In some states, you can't ever take that out of their wages. That's not necessarily in the FLSA. The FLSA says you just can't take them below minimum wage. In a lot of states, you can't deduct things like breakage or shortage. Some states require that written consent requires the amount to be known at the time consent is given for a wage deduction. Requiring written consent is not in the FLSA, but it is in most state laws. Most states require the amount to be known at the time an employee gives consent to a wage deduction. So in many of you in your states, having a blanket employer can always deduct whatever out of my wages in the handbook, and you sign the handbook, that's not going to cut it. You need to get their consent to the wage deduction once you know how much you are actually going to be deducting. compensable time, engaged to wait, or waiting to be engaged. So this is, the DOL likes to, they've got a lot of fact sheets out to kind of try and explain the big parts of the FLSA, and they use some examples, and this one I love. They use the example of a secretary reading a book while waiting for dictation. Yes, DOL, it's 2022. But or a firefighter playing checkers while waiting for an alarm. That's someone whose time would be compensable, even though they are not currently engaging in a job duty. So they're waiting to be engaged. So that even though they're doing something personal, their time is not their own. Their time is the employer's time, because at any minute work is going to start. The boss is going to come out for dictation, or the fire alarm is going to go off, and they have to jump on it and start working. On-call pay to evaluate whether or not it is compensable. Check your state law. Every state has its own case law to follow. Every state, someone has sued their employer about on-call pay, and so every state has a case law that's going to get down to the nitty-gritty about what is on-call pay and what has to be paid and doesn't. So like I said, wait, here comes state law again. Simply requiring employees not to drink during an on-call period. Sometimes this is a rule for pilots or nurses, thankfully, but that does not automatically make their time compensable just because they can't use it hitting the bars. Generally, to evaluate whether or not on-call time is compensable, they consider the frequency of calls during the on-call period, the time limit to respond, the geographic restrictions placed on the employee, the ability to trade or swap on-call responsibilities, the use of a pager or cell phone to contact the employee, and the employee's ability to engage in personal activities during on-call time periods. Meetings, training, and lectures. It is non-compensable only if it meets these 4 criteria. This is generally straightforward FLSA, no real state law at play here. The fact that the attendance at the training program or lecture or meeting, the fact that one of the criteria is that it has to be not job related to be non-compensable is probably going to take any meetings or trainings you would have off the table. They're probably going to be compensable if they're not job related. Why are you sending your employee to do them? So this is pretty straightforward FLSA. Travel time, again, can get a little confusing, but the DOL does lay it out. So commuting home to work, generally non-compensable, but driving or riding from job site to job site, which is what the DOL calls travel all in a day's work, that is compensable. So if your employees go from site to site, from client site to client site, or maybe they do run errands or for work-related errands or something like that, or if it's travel, that is all in a day's work, it is compensable. For those of you who missed last month's Third Tuesday webinar on remote and hybrid workers, we did talk about how once you have a remote employee, their home becomes your job site, and how time spent traveling between their home and your office might fall under that all in a day's work category, and that commuting may become compensable. However, in an opinion letter from the DOL, again, and this is going back to all the guidance and the opinion letters and everything that attorneys research and find out about to help you interpret the FLSA. In this opinion letter, the DOL concluded that an employee who chooses to split their workday between teleworking and working in the office and if they have sufficient time in between to perform personal tasks, time spent traveling between home and work is not compensable as worksite to worksite travel and based on the continuous workday rule, which we'll get into in just a moment. But as always, watch out, California and others. Know that your state can give employees more compensable time than the feds, not less. So check with counsel to see how your state is handling it. The home to work on a one-day special assignment, how you can subtract that usual commute time. You have to be so careful on determining their usual commute time. It may be just to err on the side of caution and not deduct that. Overnight travel, if they usually work Monday through Friday, 9 to 5, 9 to 5 on Saturday and Sunday is now compensable too. Portal to Portal Act, not required to pay for preliminary or post-preliminary activities. So example, washing up before and after work is a preliminary and post-preliminary activity. It is non-compensable. However, if your job involves caustic or toxic materials, washing up may be integral and indispensable because it involves worker safety. It becomes compensable. Donning and doffing, putting on clothing, protective gear, just getting dressed, regular clothes that you could wear on the street, that you could wear in your car on the way to work, putting those on at home or when you get to work is non-compensable. Waiting to put on your protective gear is non-compensable. Putting on your protective gear is compensable if you are required to wear protective gear for the job. Walking from the door to your desk and an office job is non-compensable. Walking from the area where you put on your PPE to the work floor is compensable. Wearing PPE is integral and indispensable. Your day starts when you put on your PPE. Once you put on that PPE and walk out of the locker room door, your workday has already started. That is why for you, walking to the work floor is compensable. State laws vary on donning and doffing. They can't give you less protection than the FLSA. Again, the Portal to Portal Act basically says, can you perform your job without doing it? And this is a very vague overview. The Supreme Court has a lot to say interpreting the Portal to Portal Act, and that, as always, counsel would have the most information about that. But the Portal to Portal Act says, can you perform your job without doing it? If you can't perform your job without doing it, then it is compensable time. Obviously, you can't do your job unless you leave your house or walk from the parking lot to the door. That's not what they're talking about. Compensable time could be booting up a computer and launching software, returning keys and equipment. Non-compensable could be receiving your work assignments and mapping out the routes that you're going to take that day. Please ask counsel, don't interpret this list yourselves. Please let us interpret that list for you. The Portal to Portal Act expressly says that use of an employer-provided vehicle does not turn commuting time into compensable time. So just because someone is commuting between home and work in your vehicle, that does not mean that it is compensable time because they're using your vehicle instead of their vehicle. It is still home to work, and that is not compensable. If you have a situation where you require your employees to meet in a central location, so they all come from home and meet in a central location and then travel to the job site in a company van, and I have had this question specifically come up a couple times, federal courts have said that this time is not compensable. So even though they all show up at the central location and then they're sitting in the company van to get to the job site, federal courts have said the time that they're sitting in the van is not compensable. But as always, check with your state. It could be different in your state. The continuous workday rule, the DOL regulations generally define workday as the period between the commencement and completion on the same workday of an employee's principal activity or activities, and includes all time within that period whether or not the employee engages in work through all of that period. So the FLSA governs the workday, such as whether a meal or rest break is compensable time. Portal to portal governs activities performed before or after the employee starts the workday. Standing in line for security checks, non-compensable according to the feds. Again, your state may have case law that differs. The rounding rule, this is another very common question. The DOL knows that small amounts of work can't be precisely recorded. You can't set up a situation that always advantages you and always disadvantages your employee. You cannot say if an employee punches in at 8:06, we round it up to 8:15, but if the employee punches out at 5:09, we round it back to 5. It can't go both ways in your direction, in your favor. It has to work out so that over time, both parties will be equal. If you track time to the closest quarter hour, use the 7-minute rule in determining which way to go. As far as discipline, if their start time is 8 and they come in at 7:54 and you round it and you say that's 8 o'clock, do not discipline them for coming in at 8:06. You can't take minutes away where they're technically not being paid for that time, even though they're working, because you're telling them, hey, that's too small of an amount of time to count. And then punish them for being late in an increment that you told them was too small to count when it came to paying them for their work. So if you are rounding, don't punish an employee for being late in one direction if you're rounding time when they start early in the other direction. The de minimis rule, generally the factors are the amount of daily time spent on the additional work, the administrative difficulty of recording the additional time, the aggregate amount of compensable time, the regularity of the additional work. When compensation for a task imposes no additional burden on the employer, there is no justification for denying the employee compensation for the task. So unless you have a justifiable burden on you that prevents you from keeping track of that time, you cannot do this. You cannot round it. It has to be a necessity of timekeeping. State law, again, it may be more specific and strict about rounding, but this is the federal rule. Lactation breaks, the Patient Protection and Affordable Care Act amended the FLSA to require lactation breaks. State law may require pay for lactation breaks. The FLSA does not require that these breaks be paid. The state law may allow breaks continuing for more than 1 year after the birth of the child. The FLSA only requires you to provide breaks for up to 1 year after the child's birth, although I do caution you when it comes to lactation breaks, discriminating on the basis of pregnancy or conditions related to pregnancy, post-birth and pre-birth are that can be considered discrimination based on sex. So you want to tread very lightly and make sure you're following this to the letter when it comes to lactation breaks. And if it comes to denying lactation breaks, that's something that you really need to talk to counsel before you're going to do that. There is an undue hardship for small employers, but proving that undue hardship is going to be an uphill battle for you, and so that's going to be very specific circumstances for you to not have to provide lactation breaks. Meal and rest breaks. The FLSA does not require breaks, but state law might. However, if you do provide breaks, the FLSA steps in and starts regulating those breaks. So breaks of 20 minutes or less are compensable time. whether your state requires you to give breaks, whether you choose to give breaks. If the break is 20 minutes or less, you have to pay for it. You cannot tell your employees you get 2 10-minute unpaid breaks. No, a 10-minute break is a paid break according to the FLSA. It does not matter what the employee is going to do during that 10 minutes. That would be a paid break. You can't not pay people for smoking. You can tell them how many breaks they get, and you can tell them you only get 2 10-minute breaks a day to go out and smoke. And I'm sorry if you want to smoke more often than that, but that's not allowed. You can certainly do that. You can certainly discipline them for going out and taking more breaks. But if they are taking, if you do provide breaks and they use it for that reason, you do have to pay it. Check your state law. Like I said, there could be a whole range of penalties for failing to give meal and rest breaks according to state law. Like I said, you don't want federal DOL opening your books, and you don't want your state's DOL doing it either. An employee during a meal break has to be completely relieved of all duties. He's not relieved of all duties if he has to an office employee who's required to eat at his desk, a factory worker who is required to eat at his machine, that's not completely relieved of all duties. You do not have to allow employees to skip breaks so that they can leave early. You do not have to allow employees to combine breaks to have one big long break. If your employees are not taking breaks in accordance with state law, do not auto deduct. Please don't auto deduct breaks. This is one way I see employers getting in a lot of trouble. If you have any reason to believe, any inkling, any suspicion that they did not take their break, pay them for that break. Your recourse, if you see this happening with your employees, is to discipline them for not taking breaks. Make your break policy clear that breaks are required and that employees will be disciplined if they do not take their breaks. Record keeping. This is what the DOL expects you to keep on every single one of your employees for a full 3 years. Records, again, failure to keep proper records resulted in a multi-million-dollar judgment against an employer. So this is something that's very serious. This is all you. This is not assume that your payroll provider is doing this and you'll be okay if you're audited. The DOL does not care what your payroll provider does. They come after you, not your payroll provider. The FLSA does not require pay stubs. Many state laws do. Make sure you check with counsel so you know what needs to be on your state's pay stubs. Some states require start sheets or prior notice if you change hours or compensation. The FLSA does not. The FLSA just requires employees to be paid on payday following the pay period. States make the law about how frequently the payday has to occur. So if you have questions, please, you can go to myhrcounsel.com and check out, if you're not one of our clients, you can certainly check out our packages, see our offerings. You can, all of the things that I referred to today as things that you should consult with counsel on. As a client, you would be able to consult with us on all of those subjects and so many more. If you have questions, you can contact us at info@myhrcounsel.com, or like I said, go to myhrcounsel.com/packages and see what is available in terms of subscription. If you are a client, log in to our Ask an Attorney system and submit a ticket at any time about wage and hour issues or any employment law issues. We are here to help. So I'd like to thank you all for participating in the webinar today, and I hope you all enjoy the rest of your day.